Good evening, everyone. To begin with, let me introduce to you our group, and we are Saiden Nicole Artumanon, Maria Anali Eliasa, Trisha Mary Dayan Tito Mampil, and Nelisel T. Ruiz, and we are Pag namain kita, akin ka na. The Miners! Thank you! Once again, classmate, I'm back. There's some sort of changes in our presentation since we decided to discuss first the definition of terms so that it would be easier for the next group and for the next reporter to discuss their topics. So to begin with, the first term is the word government, which is obviously means the government of the Philippines. Next is the department, which is the Department of Environment and Natural Resources. The word bureau, which is the Mines and Geosciences Bureau. The word president, obviously it's the president of the Philippines. Next is the secretary, which means that it is the secretary of the DNR, or the Department of Environment and Natural Resources. Next is the director. The term director represents the director of the Mines and Geosciences Bureau. Okay, our next term is contractor. A contractor is a qualified person acting alone or in consortium who is a party to a mineral agreement or a financial or technical assistance agreement. So, next question is, what is a qualified person? A qualified person is any citizen of the Philippines with capacity to contract, or a corporation, partnership, association, or a cooperative organized or authorized for the purpose of engaging in mining activities. So next is, what is a mineral agreement? A mineral agreement is a contract between the government and a contractor involving a mineral production sharing agreement. The example of mineral production sharing agreement is the co-production and the joint venture agreement. So what is joint venture agreement and co-production? So joint venture agreement is an agreement where a joint venture company is organized by the government and the contractor, with the both parties having equity shares. Aside from the earnings in equity, the government shall be entitled to a share in the gross output. So next, I will discuss about the gross output later on. So the next is the co-production. It is an agreement between the government and the contractor as well, where the government shall provide inputs to the mining operation other than the mineral resources. So aside from the natural resources to mineral resources, the government will give their share on the inputs like the infrastructure that. Okay, classmate, our next term is the ancestral lands. All lands exclusively and actually possessed, occupied, or utilized by indigenous cultural communities by themselves or through their ancestors since time immemorial. Next is the word block or meridional block. It is an area bounded 1/2 minute of latitude and 1/2 minute of longitude, containing approximately 81 hectares in area. The next is carrying capacity. What is carrying capacity? Is a capacity of natural and human environments to accommodate and absorb change without experiencing conditions of instability and a tendency to degradation. So that's carrying capacity. Okay, next word is Environmental Compliance Certificate, or ECC. A document issued by a government agency concerned certifying that a project under consideration will not bring about an acceptable environmental impact. Next word is Environmental Impact Statement or EIS. A document which aims to identify, predict, interpret, communicate information regarding changes in the environmental quality associated with a proposed project. Next word is exploration. Exploration is searching or prospecting for mineral resources by geological, geochemical, or geophysical surveys, remote sensing, test pitting, trenching, drilling, shaft sinking, tunneling, or any other means. Next is financial or technical assistance agreement. A contract involving financial or technical assistance for large-scale exploration, development, and utilization of mineral resources. Next is contagious zone. Contagious zone refers to water, sea bottom, and substration measured 24 nautical miles seaward from the baseline of the Philippine archipelago. Next is contract area. Means a land or a body of water delineated for the purpose of exploration, development, or utilization of minerals found therein. Next word is development. Development is work undertaken to explore and prepare an ore, body, or a mineral deposit for mining. And next is ecological profile or eco profile. It's a geographical based instrument for planners and decision makers which present an evaluation of environmental quality and carrying capacity of an area. Next is utilization. Utilization is the extraction or disposition of mineral. That's it, and I hope you learned something. Thank you.
So for the next part, I will be discussing to you the evolution of the pertinent governing laws in our mining system in the Philippines. This is the Spanish law, which is the prevailing mining law during the Spanish colony before the cession of Philippines to the United States during the Treaty of Paris on the Royal Decree of May 1867. Next is the Philippine Bill of 1902, which is the governing law during American occupation. This rejected the idea of regalian doctrine. This is patterned under United States Federal Mining Act. This allows qualified person to locate mineral claim and to locate flat ground. This also um, allows a holder of mineral claim to mine within the boundary of his claim. This includes also the governing law regarding the location, the manner of recording, and the works necessary to possess mining claims. Next is Act Number 624, which amended the Philippine Bill of 1902. This prescribes also regulation to govern manner of location and manner of recording mining claims, and amount of work necessary to hold possession. Next is the 1935 Philippine Constitution. This declares that all natural resources, including mineral land and minerals, is property belonging to the state. This adopted the idea of regalian doctrine. The only exception is that those with existing rights, grants, lease, or concession at the time of the inauguration of the government established under this constitution, they maintain the permits or their claims they have before the adoption of this constitution. Next is Commonwealth Act Number 137, which is also known as the Mining Act. This adopted the idea of regalian doctrine existing in the 1935 Philippine Constitution. Next is ordinance appended to the Constitution, which is also known as parity right, which amended the existing Mining Act. Next is Executive Order Number 141, which is promulgated during the time of former President Marcos, whereas the mining claim holder under Philippine Bill of 1902 with impression that they may hold under claims indefinitely with mere filing of affidavits of annual assessment work. This EO declares that such impression is not correct. For what matters in maintaining and preserving possessory title to the claim is the continuous filing of the affidavit which may be disapproved by finding on the grounds. This means that under the Philippine Bill 1902, the holders believe that they can claim mining lands or mining grounds indefinitely, but with this EO 141, they are subject now for approval, and it can be disapproved if there is violation on their part. Next is Presidential Decree Number 463, which revised the existing Mining Act. Under this decree, accessory rights of mining claim holders under Philippine Bill of 1902 remains effective as long as the said holders comply with the annual work requirements. Next is Presidential Decree 1214, which requires all holders of unpatented mining claims to secure mining lease contract under PD number 463. Next is the 1987 Philippine Constitution, which reiterates the dominant feature in 1935 and 1973 Constitution over the ownership by the state to all natural resources. Thus, all mineral lands as part of the country's natural resources belong to the Philippines. And this adopted and emphasizes the Regalian Doctrine. Next is Republic Act Number 7942, which is also known as the Philippine Mining Act of 1995. This institute a new system for the exploration, development, utilization, and conservation of natural resources of the country. This defines the modes of mineral agreement for mining operations, outlines the procedure for their filing and approval, assignment and transfer, and withdrawal, and fixes the terms. This prescribes the qualification of contractors and grants them certain rights including timber, water, and easement rights and rights to possess explosives. The Act restricts the condition for exploration, quarry, and other permits. This also penalizes certain acts. The law likewise specifies grounds for cancellation, revocation, and termination of agreement and permits. In addition, the NR Administrative Order Number 95-23, Series of 1995, otherwise known as the Implementing Rules and Regulations of RA 7942. This was later repealed by the NR Administrative Order 96-40. This is the rules and regulations promulgated for the guidance and compliance of all concerned regarding the mining here in the Philippines. This will further be discussed later on succeeding reports. In one case, the court underscored the policy of the country's mining laws to promote national growth through the grant of supervised exploration and development of mineral resources to qualified persons, necessitating the complete and prompt compliance with requirements. The instant case does not merely involve the delay filing of the requirements under DMO number 97-07, but the complete absence thereof. Consequently, petitioner's application for the MPSA is deemed to have been automatically denied when the deadline lapsed without her submission of the pertinent requirements. The court ruled under Presidential Decree Number 463, or the Mineral Resources Development Decree of 1974, was the operative law at the time petitioner filed her application for Mineral Production Sharing Agreement, or MPSA. It underscored the importance of mineral production to the growth of national economy and the need to encourage qualified persons to undertake the exploration and development of mineral resources. Whereas mineral production is a major support of the national economy and therefore the intensified discovery, exploration, development, and wise utilization of the country's mineral resources are urgently needed for the national development. Whereas the existence of large undeveloped mineral areas and the purification of small mining claims deter modern development of the country's mineral resources and urgently require well-planned exploration, development, and systematic exploitation of mineral lands to accelerate production and to bolster the national economy. Whereas effective and continuous mining operations require considerable outlays of capital and resources, and make it imperative that persons possessing the financial resources and technical skills for modern exploratory and development techniques be encouraged to undertake the exploration, development, and exploitation of our mineral resources. Whereas the foregoing objectives cannot be achieved without the shortest possible time, without removing the deficiencies and limitations of existing laws and improving the same in order to provide a modernized administration and disposition of mineral lands, and to promote and encourage the development and exploitation thereof. RA number 7942, or the Philippine Mining Act of 1995, the present law on mining, adopts a similar policy. Section 2, Declaration Policy, RA number 7942. All mineral resources in public and private lands within the territory and exclusive economic zone of the Republic of the Philippines are owned by the state. It shall be the responsibility of the state to promote their rational exploration, development, utilization, and conservation through the combined efforts of the government and the private sector in order to enhance national growth in a way that effectively safeguards the environment and protects the right of affected communities. RA number 7942 defines the persons qualified to undertake mining operations as any citizens of the Philippines with capacity to contract, or a corporation, partnership, association, or cooperative organized or authorized for the purpose of engaging in mining, with technical and financial capability to undertake mineral resources development and duly registered in accordance with law at least 60% of the capital of which is owned by the citizens of the Philippines.
My topic is about ownership of mineral resources. Section 2, Article 12 of the Philippine Constitution provides that all lands of the public domain, waters, minerals, coal, petroleum, and other mineral oils, all sources of potential energy, fisheries, forests or timber, wildlife, flora and fauna, and other natural resources are owned by the state. With the exception of agricultural lands, all other natural resources shall not be alienated. The exploration, development, and utilization of natural resources shall be under the full control and supervision of the state. The state may directly undertake such activities, or it may enter into co-production, joint venture, or production sharing agreements with Filipino citizens or corporation or associations, at least 60% of whose capital is owned by such citizen. This provision echoes the concept of Holy Regalia, or the Regalian Doctrine, pursuant to which all lands of the public domain belong to the state, and that the state is the source of any asserted right to ownership in land and charged with the conservation of such patrimony. All lands not appearing to be clearly of private dominion presumptively belong to the state. The Regalian doctrine is intended for the benefit of the state, not of private persons. The rule simply reserves to the state all minerals that may be found in public and even private land devoted to agricultural, industrial, commercial, residential, or for any purpose other than mining. Thus, if a person is the owner of agricultural land in which minerals are discovered, his ownership of such land does not give him the right to extract or utilize the said minerals without the permission of the state to which such minerals belong. Once minerals are discovered in the land, whatever the use to which it is being devoted at the time, such use may be discontinued by the state to enable it to extract the minerals therein and the exercise of its sovereign prerogative. The land is converted to mineral land and may not be used by a private party, including the registered owner thereof, for any other purpose that will impede the mining operations to be undertaken therein. The Regalian doctrine then extends not only to land, but also to all natural wealth that may be found in the bowels of the earth. The right to possess or own the surface ground is separate and distinct from the mineral rights over the same land. Ownership of mineral deposits by the state is also a dominant principle expressed in PD number 463, otherwise known as the Mineral Resources Decree of 1972, Section 4 thereof, which states that the ownership or the right to use public or private lands, whether exposed or submerged, for agricultural, logging, industrial, commercial, residential, petroleum exploration and or exploitation, or purposes or any purpose other than mining, does not include the ownership of, nor the right to develop, exploit, or utilize the mineral deposits found in, on, or under the surface of such lands, except with respect to quarry resources as provided for by this decree. Ownership of natural resources by the state is likewise reiterated in RA 7942 or the Philippine Mining Act of 1995. Section 4 thereof states that mineral resources are owned by the state and the exploration, development, utilization, and processing thereof shall be under its full control and supervision. The state may directly undertake such activities or it may enter into mineral agreements with contractors. The state shall recognize and protect the rights of the indigenous cultural communities to their ancestral lands as provided for by the Constitution. Such ownership is also reiterated in DENR Department Administrative Order Number 96-40, which states that Section 2 thereof, all mineral resources in public and private lands within the territory and exclusive economic zone of the Republic of the Philippines are owned by the state. It shall be the responsibility of the state to promote their national exploration, development, utilization, and conservation through the combined efforts of the government and private sector in order to enhance national growth in a way that effectively safeguards the environment and protects the rights of affected communities. The exploration, development, and utilization of the country's natural resources are matters vital to the public interest and the general welfare of the people, for these natural resources constitute the exclusive heritage of the Filipino nation. Full control and supervision by the state as embodied in the Constitution. The adoption of the concept Jura Regalia, that is, all natural resources are owned by the state, as embodied in the 1935, 1973, and 1987 constitutions, as well as the recognition of the importance of the country's natural resources, not only for national economic development, but also for its security and national defense, ushered in the adoption of the constitutional policy of full control and supervision by the state in the exploration, development, and utilization of the country's natural resources. The economic policy on the exploration, development, and utilization of the country's natural resources is geared towards, as enunciated in Section 1 of the 1987 Constitution, for equitable distribution of opportunities, income, and wealth, for a sustained increase in the amount of goods and services produced by the nation for the benefit of the people, for an expanding productivity as the key to raising the quality of life for all, especially the underprivileged. Activities which may be undertaken by the state in connection with its full control and supervision. First, the state may directly undertake such activities. Second, the state may enter into co-production, joint venture, or production sharing agreements with Filipino citizens or qualified corporations. Third, Congress may, by law, allow small-scale utilization of natural resources by Filipino citizens. Fourth, for the large-scale exploration, development, and utilization of minerals, petroleum, and other mineral oils, the President may enter into agreements with foreign-owned corporations involving technical or financial assistance.
So back then, Filipino people have the inherent right to own a natural resources as part of their natural lands, in which now it is vested in the Philippines or the state of the ownership thereof. A locator is when one person discovers a land in where he discovers a mineral underground, perfects his claim, and location will now have a possession or exclusive right upon that land, which will now have exclusive activity on that land, and also will have an exclusive right not only against the third person but also against the government. This right was vested under the Philippine Bill of 1902, which is prior the effectivity of 1935 Constitution, that even the government cannot impair this right. So in order for a perfect mining claims or convert a land into a mineral land, one or the locator must comply with the requirements, which is the registration and also the performance of annual work. As he said, that just a mere registration or location is not absolute. It is just a mere separation of that land or protection of that person, of ownership of that person against the other would-be locator and from the activities that can be practiced by other people on that land, or getting other mineral resources from that claimed land. So under PD or Presidential Decree Number 1214, which requires all locators to secure a mining lease contract under the provision of Presidential Decree Number 463, patent to their mining claims. So there was a discussion regarding the constitutionality of this presidential decree, and it was said that, as he said, it is constitutional because it is in accord with Article 14, Section 8 of the 1973 Constitution, and also Section 2, Article 12 of the 1987 Constitution. It is but right because it is a valid exercise of the sovereign power of the state as the owner of the lands and the public domains. So under the present Constitution, it is said that all other lands or resources cannot be alienated except the agricultural lands. So, therefore, mineral lands cannot be a subject of patent. Under the Regalian Doctrine, which serves the right of the state upon the natural resources found in the country, the state, or the territory, which means even a private person on his private property cannot rightly utilize or extract mineral resources on his land unless otherwise he will get a permit or without the permission of the state. This is not absolute, for the Constitution provides for the exception and also for the people to use the natural resources within the state, in which number 1 is under the agrarian reform, which gives the people the right to exercise or use the agricultural lands, and also for the fishermen to use the fishing resources inside the country. So there is a protection of our mineral resources and mineral lands. It is called the Mineral Reservations. It is established by the government. So under the Mineral Reservations, it is the reservation or preservation of our natural resources in order to be used for the national development, other raw materials, and scientific uses or value. So under RA number 7942, there can only be a 25% of the maximum area that can be used for the small-scale mining activities. So RA 7942 Section 19, which provides for those areas closed or cannot perform even the small-scale mining. It provides that it cannot allow the mining operations in those areas, in which some are in military areas or governmental areas, or those areas that is expressly prohibited by law, and also to those virgin forests. So the court declared that operations or explorations on the government areas is prohibited under PD number 463 unless otherwise permitted or allowed by the state or the government itself. So in order to have mining activities on the government areas, every person or those wanted to have mining activities on this area must secure permits that is provided under the PD 463. So in conclusion, before the Filipino people under the Philippine Bill of 1902, which allows the Filipino people or the locators to acquire natural lands as part of their natural wealth, in which when they acquire that land, they have the right to explore the natural resources found therein. But right now, in the present constitution and laws, only the state or the government have the right to explore and allow the explorations in such areas, especially those mineral reserved areas. So in order to conduct activities, like for example, mineral operations or mineral activities, one must secure permits, and also there can be a law that must permit the activities in such areas.
Thank you for listening. We are the Group 2.